me about running for state's attorney.
Well, the first time I ran, I had been first assistant state's attorney under a man named Bill Guile, who was he got elected county judge, so there was a vacancy. The county board got the appointment for the vacancy for that pro temp, and they picked the attorney for the county board chairman. And he offered me the job if I would, first assistant, if I wouldn't run against him. And I said, no, I know more about this job than you do, and I can do a better job. So I ran against him and beat him. Then in the general election, I'm against Prentice Marshall, who, as they said, was the best Democrat who ever ran in DuPage County. He was running against a Republican who was also highly qualified. And I won. Anyhow, that was 59. But as a result of the campaign, he and I became fast friends, and we were till the day he died. So that years and years later, I get even with him. I suggested to Charles Percy, I was at least one of several, but I was vocal about it, to Percy that he ought to appoint Prentice to the district court. And that didn't sit well with the general Republican Party itself. But Percy wanted good judges, and he got good judges. And he got credit for appointing great judges, so after that he could appoint people. John Powers Crowley, George Layton, after whom the criminal court building's name, was appointed a federal judge by Charles Percy. Well, he advised the president to do it. And
so the qualifications of the judge as opposed to the Republican or Democratic label.
There is no such thing as a good Republican or a good Democratic judge or prosecutor. There are good prosecutors and bad prosecutors, good judges and bad judges, but not on political labels. So, and if you do it, you're making a terrible mistake.
Why did you decide to become a judge?
I didn't quite decide there was a vacancy. I had been re-elected state's attorney, and I was finishing the first full term. And the vacancy came up, and it was convention nomination. The conventions meet of the two parties and select candidates for judicial office. And I didn't like the one man who was far ahead in the Republican caucus, and he was going to be elected if he could have it. I could beat him, and I did. Now, lurking back there were several men on the bench that I had learned to admire over the 7 years I'd been busy practicing law in front of them. So no more, 14 years. And I thought they were doing a wonderful job at advancing justice, and they seemed at ease with the job. So I had role models I could follow. So I ran, got nominated, and got elected.
So I want to shift gears for a minute.
Surely.
And talk about your very illustrious and long judicial career. You started as a judge in DuPage County.
Right.
And now you've been 42 years as
on the Court of Appeals.
Yeah.
And in between time, I served a little over 3 years as a district court judge on the same district court. So I was a trial judge about 9 years.
You've had a wide array of judicial experiences. What have you liked most about being a judge?
I like it all. It's hard to pick out most. I work with very good people. I encounter very good lawyers, all almost without exception, intent on trying to do the best they can to bring the maximum amount of justice, the maximum amount of fairness to the system, and with the minimum cost. That, however, is not an overbinding selection of the lawyers. But I admit, part of it has become more business than it used to be. But that's just because it's gotten so big.
When you were chief judge,
right,
there was an initiative to put in place at the Seventh Circuit professionalism standards.
I was aware of the fact that there were complaints about lawyers that were not civil to one another, particularly in situations where the judges could not monitor it, depositional things, that sort of things, private correspondence on. But some of it occurred right before the judge without any admonitions or slowing down. I wondered whether this was just me or whether it was a feeling among the lawyers. And so I asked Marv Aspen, a district court judge that I was close to, if he would head up a committee to look into this. And in the Seventh Circuit, which is Illinois, Indiana, and Wisconsin. And he reported, in that report of that committee, and we had people from all areas participating, became the rule that is now been adopted, not just by the Seventh Circuit, but almost across America. It's one of the prized things, including the Philippines, by the way. Not America. I had a letter thanking me, asked me for a copy from the Chief Justice of the Philippines. I sent him a copy, and he thanked me kindly, and they adopted it. But the point of the matter is, it sets out very specifically what kind of behavior is acceptable to be a member of the bar or to be a judge, because it was found necessary because people seem to have lost contact with each other. Here, let me tell you. We found out, for instance, that Aspen's committee found out, and I agreed, that the bulk of the incivility occurred in major areas like Indianapolis, Chicago, Milwaukee, Rockford. You got into the hinterlands and the downstate, there was very little. And that's largely because every lawyer knew every other lawyer, and you're going to encounter the same people over and over again. That kept you on your toes, because if you were uncivil to somebody, he might be uncivil back to you. In those small towns, they found out anybody who was not civil, and they shunned them. It's impossible in the bigger areas. So you have to say, this is why you do it, and give them a reason for it. It is not only the right thing to do, it is the economic thing to do, it is the intelligent thing to do, and it produces good for you as well as everybody else.
In those Seventh Circuit professionalism standards, there's a portion directed to judges.
You bet.
What is the role of judges with respect to civility?
We'll talk about role models. They set the tenor, and they, even in permitting incivility between lawyers, they're setting the tenor. If they stop it, and they can, without being rude, just don't do that. And hardly anybody fights with the judge or when he tells them what not to do. But when there are relationships with the lawyer, the judge to the lawyer should be civil. It should be decent. He expects them to be civil to him or her. The judge should be civil back. And they set, as I say, the tenor for the whole trial and for the profession itself. So it was necessary that Judge Judy doesn't run the program. Beyond
civility within the courtroom, what do you think the importance of civility is to the profession, and particularly to society looking at the profession?
Well, society, judges, the lawyers, like the judges, they expect the maximum justice from people who are decent to them. And if they're not, if they're bullies, most bullies, by the way, are insecure. And so if you're insecure as a lawyer, you have a tendency to be a bully, to show that you really know what you're doing. You don't. Judges, same thing. If people lose faith in lawyers and judges, they've lost faith in America, because that's what makes us unique, that everybody is supposed to be following the rules. The rules are set up so that we can live together in relatively peaceful harmony, both on a business basis and person to person, and group to group. And lawyers are the mouthpiece for the inarticulate, the spokesman for the inarticulate, for the rich, for the poor, to make sure the rules are being lived with. There's a tendency for people to push the rules. John Adams, our second president, said before he was second president, it is prudent not to put virtue to too serious a test. And he was right. People have a tendency to push. Ambition becomes greed. So you have to watch it. And if people do this, to follow these rules, have to be nice to each other to keep people's faith in it alive.